This lecture covers the material that's discussed in Chapter 8 of the textbook, continuing our study of substantive matters of law, this time criminal law. This will be followed by Chapter 9, which discusses criminal procedures. Both of these classes are, depending on the law school you might attend, between 1 semester and 2 semester classes in law school. So you'll see that we are just touching on the highlights of these areas, and hopefully you'll be interested to learn more. Just a reminder, pay attention to the case studies in the textbook and the questions that are posed in the textbook. They help us understand and put a context to the subjects we're discussing. Criminal law is largely a state law matter. The exception to this, of course, are matters that are subject to federal criminal laws. But again, each state has its own different set of similar of criminal laws, and some acts that are perfectly legal in other states are illegal in other states. Gambling, use of marijuana, prostitution, and now abortion. These are all dependent upon state laws, and again, some conduct is legal in other states and illegal in others. The textbook discusses at length the Model Penal Code. The Model Penal Code has not been adopted in California, so we're going to be focusing on both the Model Penal Code and California matters, and occasionally discussing the differences. As the slide indicates, a crime is something that has been prohibited by the legislature of the state and enacted in law. So again, a crime is what society says is a crime, and society speaking through the government. Crimes are matters of public order, and we contrast that to tort law, which you recall is designed to compensate private wrongs. Again, many acts that can be both a tort and a crime. And the difference, of course, is being the party that brings the legal action. In tort law, it is the harmed person. In criminal law, it's a state. And of course, the punishments and verdicts are far, far different. We again focusing on California law, because we are a big state. Many California penal code sections are so famous or infamous, as the case may be, as to be known by shorthand. Most of you have probably heard the term Penal Code 187. If you haven't, it's the definition of murder, which in California is the unlawful killing of a human being or a fetus with malice aforethought. Crimes are classified in all jurisdictions into 2 basic categories, felonies and misdemeanor. The general difference between the two is that a felony is a crime that is punishable by imprisonment by 1 year or more, and that, at least in the state, is in a state prison. In contrast, a misdemeanor is a crime that's punishable by less than 1 year, and the punishment is served in a county jail. Crimes can further be classified based upon the type of harm to society. The textbook breaks down into 4 categories: offenses against the person, crimes against habitation and property, crimes against public health, safety, and decency, and crimes affecting governmental functions. This slide shows the chart at page 213 of the textbook, which breaks down those different types of classifications and shows the various crimes that fall within the classification. It's important that you review the textbook material that discusses these various types of crimes, and particularly pay attention to the elements of each crime that are discussed in the in the textbook. Again, the elements of a crime are important. The prosecution in our system of criminal law is required to prove each and every element of a crime and prove them by beyond a reasonable doubt. If just one element of a crime is missing, then a conviction cannot be obtained. The two basic overall elements that are involved in criminal law, apart from the elements that are specific to each crime, are bad intent and bad act. We use the Latin phrases mens rea to talk about bad intent and actus rea to talk about bad act. You can have a bad act, but if there wasn't the intent behind it, it's not going to be a crime. It may be tort, but again, criminal law requires the bad intent. On the other hand, you can have a bad intent, but not have a completed act. This, nevertheless, may be a crime. Many of you have heard of the preface attempted before a crime, attempted murder, attempted burglary, attempted robbery. In those situations, you had a bad intent, but a failure to complete the bad act. Nevertheless, the intent itself is a crime. Similarly, you may have people that are involved in planning or aiding and abetting the commission of a crime. They don't necessarily commit the crime itself, but they do have bad intent, and they engage in such actions as conspiracy or solicitation. Solicitation being encouraging someone to commit a crime. Again, different types of all crimes have this bad intent element. Oftentimes, the difference in the classification of a crime and different levels of a crime depends on the different levels of intent. An example of that being homicide. A homicide it simply means taking of a life of a human being. But there are various types of homicide. Murder is a type of homicide. Manslaughter is a type of homicide. Manslaughter is often broken down into voluntary manslaughter and involuntary manslaughter. All of these different levels reflect different types of intention, and hence different crimes and different punishments. The parties to the crimes are defined or set forth in this slide. And again, these reflect different levels of participation in the crimes, different levels of bad acts, different levels of intention. A principal is the person that actually commits the crime. The accomplice is the person that assists with it, but perhaps doesn't commit it. And then we have accessory before the fact and accessory after the fact. There's an excellent discussion of the differences between these different types of people, beginning at page 223 under the section Parties to the Crime and Legal Reasoning Exercises. It describes a liquor store robbery that goes horribly bad. And you can read that and focus on the different roles played by the different people in the fact pattern, from the principals to the accomplices to the various types of accessories. And again, it's an excellent discussion. Again, an action that might be criminal, there may be also a defense to it. And sometimes the defenses are complete defenses. Sometimes these defenses are partial defenses. I'm not going to go over all of the defenses that are discussed in the textbook. I leave it to you to read the textbook. I just want to highlight a few of them. One of them that comes within the category of alibi defense is a Sadi defense. That's a term that I heard from a criminal law attorney that I met one day going to court. He told me he was defending somebody in a criminal action, and I asked him, what kind of case? And he just very flippantly said, "Oh, it's a Sadi case." And I've been a lawyer for quite some time. I'd never heard that term, and said, "Well, what do you mean by Sadi?" And his response was, "Oh, some other dude did it." So again, that's an alibi defense. Somebody else did the actual act. Entrapment, you often hear about as a defense to a crime. This simply refers to a situation where a defendant essentially admits to committing the crime, but alleges that they were tricked or led to commit the crime by law enforcement. Entrapment cases are very, very difficult to prove. Again, you start off with the basis that the crime was committed. A recent example of this that some of you may be familiar with are a former Los Angeles Dodger player, Yasiel Puig, was recently charged with crimes related to gambling. And originally, Mr. Puig had agreed to plead guilty to the crime with a recommended sentence of probation only. Later, Mr. Puig changed his plea, found new attorneys, and sought to fight the case based on an entrapment defense. The self-defense, again, is a very important type of defense, and it most often comes up in the context of physical altercations, and there are particular levels of self-defense that are appropriate. Perhaps the most famous type of self-defense statute is what we call a castle doctrine, referring to somebody's home. And what that doctrine means is that persons that are confronted within their home are allowed to use a much higher degree of violence, up to and including taking the life of an intruder in defense of their home. Again, pay attention to the discussion of these various defenses in the textbook. I wanted to spend a few minutes talking about the insanity defense. You often hear the term, after an act is committed, only a crazy person would do that. Most crime is incomprehensible to average citizens. So the reasoning goes, well, aren't most criminals insane to do what they do? On the other hand, isn't the insanity defense simply a way for criminals to avoid responsibility for their actions? This again, these questions pose, when the insanity defense or diminished mental capacity defense is appropriate. One thing to keep in mind when you're reviewing these different types of defenses in the textbook, whether it's the McNaughton defense or the Model Penal Code substantial capacity defense, is that there is a fundamental difference between the legal definition of insanity and the medical definition of insanity. You could have a trial where 5 psychologists and psychiatrists testify that a defendant is medically insane, and yet have that person found to be legally insane for purposes of the trial. Again, there are 2 different tests that are involved. The legal definition of insanity has generally been constant and the same for many, many years, while the medical definition is evolving as medical science evolves. So again, review the text material and make sure that you understand the difference between the various levels of insanity. The California insanity defense is a version of the McNaughton defense, and it's set forth in California Criminal Jury Instructions 3450, which is depicted on the screen. And this is a jury instruction that is read to jurors in a criminal case that in order for them to pass judgment on a claim of insanity. So the defense or the jury instruction says the defendant must prove, and again, the defendant has to prove that it's more likely than not that he or she was legally insane when she committed the crime. So the burden here is on a defendant to establish an insanity defense. And under California law, the defendant was legally insane if, one, when he or she committed the crime, she had a mental disease or defect, and two, because of that defect, he or she was incapable of knowing or understanding the nature and quality of his or her act, or was incapable of knowing or understanding that his or her act was morally or legally wrong. And again, this is a statement of the McNaughton standard. And again, under this standard, someone could be medically insane, yet be held by a judge or a jury to be not eligible for the insanity defense. Right. There are slides related to self-defense that you can look at that talk about when self-defense is appropriate. One of the things that differs in between tort law and criminal law is the end result. In tort law, the judgment seeks compensation for the victim of the tort. In criminal law, the victim of the crime, there is an actual victim, but in a sense, society is also a victim. Again, society is, the state is the one that prosecutes criminal actions. And punishment, it varies depending upon the jurisdiction and the type of crime that is involved. And again, this is one of the areas where state laws can differ markedly. The federal government and a majority of state authorize the use of death penalty, although it's very, very rarely used. Many of you may be aware in California, Governor Newsom has entered a moratorium against the death penalty. And this is against the express wishes of the citizens of the state. Several times there have been ballot measures to outlaw the death penalty in California. And the citizens have voted repeatedly in favor of the death penalty. But yet Governor Newsom has instituted a moratorium, and there hasn't, even before Governor Newsom, there hadn't been an execution in California for many, many years. In California, one of the peculiar aspects of the death penalty is there is a mandatory appeal of all death penalty convictions. And that appeal bypasses the Court of Appeal. And so we have a direct appeal that's taken from the trial court to the California Supreme Court. With this mandatory appeal and other avenues of appeal available to a criminal defendant, such as federal habeas corpus proceedings, it can and does, in fact, take decades, literally, to execute a convicted criminal. And one of the arguments against the death penalty is that the sheer amount of resources that are devoted to a death penalty litigation are just so staggering that it's really not worth it to society to continue to have that. And that if those resources weren't being consumed, they could be used for other purposes. So again, very controversial topic. One thing that has been clear, people have argued repeatedly that the Eighth Amendment to the U.S. Constitution prohibits cruel and unusual punishment. And people have argued that the death penalty, in fact, constitutes cruel and unusual punishment. That's been rejected by the United States Supreme Court. Interestingly, this is also an area that shows the difference between state and federal constitutions. There are many states whose constitutions contain same or similar language, where that state's Supreme Court has held that the death penalty constitutes cruel and unusual punishment as a matter of state law. Again, interpreting the same phrase differently. So again, showing the richness and diversity of our legal system. Many of the states, including California, have enacted states that mandate a minimum number of years in prison for specific crimes. Most of you have heard about the three strikes law, which is discussed in the textbook, and recent changes to that. Again, these are mandatory sentencing provisions. And the effect of these mandatory sentencing provisions are to remove from the trial judge discretion regarding sentences. Again, this is a very controversial provision, and it's one of these areas where in the law we have a pendulum that tends to swing back and forth, sometimes more in favor of providing more rights to criminal defendants, other times swinging the other direction and leaning more towards punishment. So again, hopefully this has been helpful to you in understanding the materials in the criminal law chapter. The next lecture will deal with chapter 9, where we're going to be talking about criminal procedures. So again, and since we have differences between the substantive criminal law, which is discussed in chapter 8 of the textbook, and procedural criminal law, which is discussed in chapter 9.